Hi, this is Anthony Parent of IRSMedic, and we have a special podcast today. There is a very, very important case coming up. The Supreme Court is going to hear oral argument on Wednesday, November 2nd at 10 a.m., and the case is called Bittner. And this case we've been talking about on the podcast, it's coming up, and it is really, really incredible what has happened, and not incredible in a good way. But really, this is a case of someone who was a U.S. expat who had foreign accounts. They weren't foreign to him, and has been assessed $10,000 FBAR penalties for the simple, innocent mistake of not filing an FBAR. And the IRS wants to assess multiple non-willful penalties. The argument's that he only should be assessed one non-willful penalty, which I don't know if I exactly agree with it. I believe 0 FBAR penalties should be assessed. And John and I have gone over the legal arguments and the lack of statutory authority for FBAR penalties. And that's another issue. We don't want to get too off track. We really want to stick to the facts of Bittner. So John, can you help us understand Bittner a little bit and what's going on and what really is at stake Wednesday on this case?
Well, I will do my best. This is, I think, an incredibly important case for a number of reasons. The first is, just to put this in context, that if there's an FBAR issue and somebody's looking at, the IRS penalty gun, so to speak, there's a provision in Title 31, 5322 for criminal sanctions, which we're not talking about today. There's a provision in 5321 for civil penalties.
Correct.
And the civil penalties are divided into the willful and the non-willful.
Correct.
Okay. So for our purposes, given that the vast overwhelming majority of these things are civil penalty cases, the first question that must be answered, the determinative question really is it willful or is it non-willful? Now, if it's willful, the penalties are likely to be massive. All right. If it's non-willful, that's the area where one can argue reasonable cause, etc., and therefore there should be no penalties. Again, to be clear, non-willful, and this is, I think, just sort of common sense, is not available, reasonable cause, rather, is not available in the case of a willful penalty, right? Because if you're willful, I mean, there is no reasonable cause. There's no reason, why you wouldn't know about this, etc. Now, what has happened in Bittner is that we have a man who is Romanian dual citizen, naturalized U.S. citizen, moved back to the United States, was a very successful businessman, probably generated a lot more money than you or I have, Anthony, or ever will. And he, I guess, decided to move back to the United States. His version, of course, is that he's learning about this. He then, like so many people who are penalized, tried to make it right by, catching up, filing these things. For reasons that I don't understand, there was a factual finding that he was non-willful, not willful, which is interesting because there have been people who factually, I think, are arguably less culpable than he is, who were determined to be willful, etc. So, it's a bit.
No question. Absolutely. There is a
factual predicate for this is that he's non-willful. So the question is, well, what kind of penalty can he be assessed if he's non-willful? And his view of this is that the penalty should be limited to the failure to file the form itself, the FBAR form, because that's the statutory requirement every year. Everybody lines up to file an FBAR. They may put multiple accounts on the form.
Whoa. Stop right there. There is absolutely no statutory requirement. This, we went over this. There's only a regulatory requirement.
Regulatory requirement. It's in the regulation, not the statute. Absolutely. In fact, to be clear, there's practically nothing in the statute at all. All the statute really does is simply says, Treasury Secretary, why don't you, put together some rules for reporting odds and ends of stuff and make up some penalties for failure to do that. But
Well, actually, and John, I just want to interject. It's actually very specific what the statute authorizes. To a degree, it's just ignored. The statute says the Secretary of Treasury shall require reporting of foreign agencies. And the statute is very clear that a bank account is not a foreign agent. The statute itself doesn't authorize FBAR penalties. It authorized something completely different that everybody's ignoring. And I think that's the bigger problem.
Let's leave that again to a more separate issue. There's some disagreement on whether bank account will be included in foreign financial agency or not. But that aside, the case is clearly moving down the track that, one, the penalties are authorized regardless of what you or I think, and that the failure to report a foreign bank account is within the purview of the regulation regardless of what you or I think. And so if it's non-willful, the regulation speaks of a $10,000 penalty max. But for what? Is it for the failure to file the form? It's the form that's required. Or is it rather for the failure to file a report of each reportable account, in which case, would be levying the penalty not for the failure to file the form, but rather a penalty on each of the subcomponents of the form, if you will. So, for example, and somebody pointed this out to me yesterday, let's take a form 5471 that, let's imagine, it has 10 schedules, and it probably does. All right. We understand the penalty for the failure to file a form 5471 of $10,000. The analogy here would be if the IRS took the position that no, it wasn't limited to $10,000. It actually could be imposed on a $10,000 penalty for the failure to file each schedule, which was part of the form, right? Hence, the issue here is whether in the non-willful context, the IRS is restricted to imposing one $10,000 penalty for the failure to file the form itself, or for, I suppose, sufficient mistakes on the form itself, or whether they can say, well, leaving aside the form, we don't really care about that. Really, okay, what we're going to do is we're going to impose the penalty separately on each account, which should have been included on the FBAR, right? So that's the issue. Now, contextually, that's the difference between $50,000 of penalties for Mr. Bittner or $2.72 million of penalties, because as I understand this, these are penalties for a 5-year reporting period with something like 50 accounts per year. So, as you can see, this is a large and important issue, and it arrives to the Supreme Court because the Ninth Circuit has ruled that the penalty should be based only on the form, meaning $10,000, and the Fifth Circuit has ruled that the government can impose $10,000 per account that should have been on the FBAR. Hence, at a minimum, my practical, simple-minded way, I would say it's a lot smarter for Americans to live in the Ninth Circuit than the Fifth Circuit, wouldn't you?
Yeah, I think you're really, really better off there. I actually didn't know that the willful penalties were that insane. The non-willful penalties added up to that. I didn't realize they were that insane. So
they're that insane if they're imposed on each potential account. Now, one of the points made by a number of the Amicus briefs here, and there's a number of them, and they're very.
And I have one up here. This is a good one here.
That one in a second. I think that one's particularly good, and I think this one also makes that point. But a point that's made repeatedly here is that with the government's interpretation of this thing, it's entirely possible for the non-willful penalties in aggregate to exceed what the willful penalty would be, right? It's also a situation where a person who failed to report one account with, say, $1 million in it could be penalized more heavily for failing to report 20 accounts with $10,000 each in them, right? I mean, it's really
incredible, a huge difference
stuff, isn't it? And so, as you know, you have to get the court's permission to hear a case like this. It's what's called a cert petition. But I found it particularly interesting to read the Solicitor General's brief in the cert petition, which basically the final paragraph, why the government ought to be able to impose these fines on a per account basis, was just pure vengeance. We want the ability to punish these people in accordance with what we think their culpability is.
So I have the government's brief right here. I have that in front of me, and we don't have the time to go over it.
But it's very long, isn't it?
Yeah, it's extremely long.
Yeah, and normally, if something's that long, it means they're struggling to find some reason.
I mean, it's really this is sort of, so here's the analogy I thought of today. Here's the analogy today. Let's say that I'm a bad boy and that I'm speeding through the center of my town. And I'm driving my big truck through the center of town and I'm speeding through town. And then one of my friends who actually works for the Wallingford, Connecticut Police Department pulls me over and says, Anthony, you've been speeding. And I said, oh, you got me. And it's like, okay, I got to give you a $200 ticket. I'm like, okay, great. Well, and another $200 ticket because you were speeding on Academy Street. And then another $200 ticket on that because you were also speeding on all these different streets. That when you get a speeding ticket, it's for the violation of which incurs multiple violations. So here, what they're doing is they're sort of making a crime out of something that isn't a crime by itself. They're making more crimes and they're not treating it as one act. They're saying, well, actually, you know what? You didn't put down this bank account. You didn't put down this bank account. So each one makes another FBAR. Wait, I thought there was one FBAR violation, but you look like you're having a multiple FBAR violation, and we don't really see that whatsoever. And I don't even think we see that I don't know if we even see that in the regulations. Certainly not the law. The law is.
No, there is no law. Okay.
Right. And that's. And I think where I was sort of getting off the track, and I'll just sort of I don't want to get off to the track here because I'm hopeful that the Supreme Court takes a bigger look at this than just the arguments at stake and actually look at the entire Title 31 in context of what it's supposed to do and how it actually works and who it imposes its obligations on and why does it make sense to have a civil end. And here's the thing to remember. The FBAR, non-willful FBAR penalties are a criminal charge. Okay? So what sense does it make to have a civil agency, the IRS, assess a criminal complaint of a different department of U.S. Treasury? Hopefully, and this is where look, this just could be my hobby horse, but I see the EPA case where it does seem like the Supreme Court went a little bit above and beyond of what was requested to say, you guys have to have, we can't have this total mismatch between what the law is and what your regulations end up being. And I'm hoping that the Supreme Court has the same sort of inquisition of the government to say, well, here, your law says this, your regulations say this. No one voted for your regulations. They voted for the law. The law doesn't support this. So I will just end it with that I am praying. I am hoping that, and maybe because this case is so ridiculous. I mean, this is ridiculous and they are greedy, aren't they? I mean, they just don't care. We just want penalties because we want to punish people.
Well, they're vindictive. I don't know about greedy. They're vindictive.
Vindictive.
Yeah.
Well, greedy because this is what they like. And this is always that they want to have the press releases for these penalties. Now, some people can pay them, then a lot of people can't. I'm working on a case of a $4.2 million FBAR willful for someone who doesn't have their whole mind, who came clean. And the IRS has said, and he can't pay that. He has no money left. And the IRS still, and it went to IRS appeals. Like, we're going to assess a $4.2 million penalty. So why would they do that? Why would they assess a penalty that can't possibly be paid?
This is an interesting question because I really do not think that it is in the interests of the IRS to be advocating for this, this per account penalty regime. I think it is going to, I think that the administration of justice, or whatever it's called, is already in extreme disrepute. And I
Yeah,
think
rightly so.
this just pushes it, over the top, where it's going to go beyond, disrepute to just ridiculing the whole thing. But of course, you and I both know that the law often has nothing to do with morality, common sense, or anything else. And, I'd like to think that we would rely on government agencies to, bring some common sense to this. And what's very, very clear is that Treasury is not doing that at all. And
Not at all. Not at all.
in the long run, they're doing themselves, I believe, a great, great disservice because, interestingly, all of these people are people who tried to comply with the FBAR laws.
They didn't catch any of these people. These are all people who raise their hand, oh, I'm in noncompliance, and you guys should be pretty reasonable with me, right? These are all, they didn't catch one person.
Now, I don't know about not just one, but by and large, these cases we're talking about, reading about, what they do seem to have in common is that these are people who realized they had a compliance problem with FBAR and in one way or another tried to solve it. And I think this is really bad behavior on the part of the government, to respond in this way. It certainly does not encourage trying to fix up foot faults, does it?
No, I can't tell. The IRS has been putting out press releases for years, telling you, hey, get your clients to comply. It's going to be better. It's going to be better. That turned out not to be so true because they haven't caught the people that they claimed they were going to catch, and they've only penalized the people. A few exceptions. You're right. There are a few exceptions here and there, and I'm not going to speak to those. For the most part, FBAR penalties have
what is
only
very,
been
very
assessed.
clear is they've been very hard, unnecessarily and unjustifiably hard and punitive on people who tried to fix these problems.
Right.
I think that is an objectively correct statement here.
And I do have that a section of the government's brief highlighted right here, and just to highlight what I was talking about earlier, okay? Because here's the government's own words, right? It's sort of they're explaining what the Bank Secrecy Act is. In Title II of the Act, as amended, Congress directed the Secretary of Treasury to promulgate regulations to impose record-keeping and reporting requirements on any U.S. resident or citizen who makes a transaction or maintains a relation for any person with a foreign financial agency. That's the law. Where does the law say anything about an FBAR? It doesn't. There is no FBAR law. Where we find it is here, where the regulations.
That's right.
Where the Secretary of Treasury, that's where and that's so key to remember. This is a regulation made up out of thin air, or not. It's actually not made up out of thin air. They took a law and they twisted and perverted it, and it obviously can't mean what they claim it means. And yet they're using this illegal, in my mind, an illegal interpretation of law, not for justice. Because the IRS bends rules all the time. They bend rules on, oh, we're not going to do it this way, do it this way instead. This is where they break the rules to act so insane. And for people, this is all a test case. What they're doing with foreign individuals is all what they bring in to every U.S. person. So this is their test case. What do you think is going to happen when there's a new filing report? Because they could clearly make it up out of thin air. Or not thin air, but they'll make, we're going to call a U.S. bank account a foreign financial agency.
Well,
let's stop them.
We have this with the new Corporate Transparency Act as well. Okay, where people have to report companies, limited partners, this sort of stuff, right? It's the same thing. It's being run out of FinCEN. And I predict, the same kinds of difficulties, although I think that the rules are somewhat more clear there. But the level of punitiveness and vindictiveness is definitely the same. All right. So, first point I want to make here for listeners is that you can actually listen to the oral arguments this Wednesday. You go to supremecourt.gov, supremecourt.gov.
Oh yeah, hang on. Yeah, let me go back to that. I just closed my screen share. Hang on, let me go. So I'm at supremecourt.gov right now, and I'm on the
Yeah,
search.
you see, yeah, go to the top there, Anthony.
Yep.
You'll see oral
Yep.
arguments.
Okay.
Go down to calendars and lists.
Okay.
You'll get there. Okay, you'll get there. Current term. Well, hang on a minute.
November.
November 2nd. Although I don't think you can click on that one, but
Yeah. So
you'll get there. Okay, because I was actually listening this morning to their affirmative action cases. And I would encourage people to actually do that. I think it's interesting. And I think you'll hear some very, very strong arguments, particularly. Well, I mean, I think many of the amicus briefs are very good, but I keep coming back to the one for the Center for Taxpayer Rights is, I think excellent. It recognizes the problems of Americans abroad, and it also comes at this from a number of points of view. All the unintended consequences of.
And so you said the brief that I clicked on, which one was it? Was from which one?
Okay, hang on a minute. Hang on. Don't. Yeah, right there. It's right there. On taxpayer. Yeah, main document. That's the one you want there.
Right. And this is this is by the More Tax Group. This is
This is very, very good. This is for. I presume that this would be the law firm of the lawyers for former taxpayer advocate Nina Olson's.
Yep.
Taxpayers Rights Center. It is a superb piece of legal research and advocacy. It really is. For a variety.
And I mean, they did this out of the kindness of their heart, right? I mean,
Oh, look! Whoa, Laura Snyder, the criminal.
Oh,
Laura Snyder's article. Fellow seat criminalization of the American cited. I must tell her that.
That's great. Yeah.
Isn't that nice? Okay.
Yeah. I mean, there's so much work put into this.
Yeah. I suspect that they're not being. I suspect they're not being particularly well paid for that. I think.
Yeah, and these are the folks that run procedurally taxing, and that's just that's one for practitioners. That's a great site for practitioners. They always have really interesting information.
This is free, but I think it does give some meaning to, assuming I'm right in this, that the best things in life are free. Although not free, you can be sure that's heavily discounted in terms of the monetary value of it. So, all those people deserve a real shout out. I've seen
here they are. Yeah, so Guinevere Moore is a tax litigation attorney.
Yeah, she with an excellent history. I've seen her speak at various places. Anyway, actually,
and I want to thank everybody who's worked on every brief, but this one's really. This is good.
Not only is this, I think very, very well done, but the reason I mention this is partly because, our audience and concern for Americans abroad, this brief specifically suggests unfairness to Americans abroad.
Yeah, yep.
That sort of thing. Yeah, see that?
Yeah, finally, yeah, that's really they get to the heart of it there.
Because you get, for example, Americans abroad is one group, but you've got all these immigrants to America, right? You come to America.
Green card holders, H-1B, these are the people that are our clients. I mean, they come up. What do you mean? I was
listening to another guy talk about this last week. He said he had a client who was, get this, okay, a cleaning lady. Somebody who works as a cleaning lady for relatively low wages, and had a couple of bank accounts in her home country, to help her parents out. And, if I'm understanding this correctly, they were hitting her with FBAR penalties. Can you imagine? I mean, this is just really, really, it's over the top, and it cries out for some kind of judicial intervention. I mean, look at this: acknowledging failure to file for the years 2007, 2011, he was in Romania for some of these years, was not willful, right? So that's the predicate. The IRS assessed non-willful penalties per account by identifying 272 accounts over 5 years, a $2.72 million non-willful FBAR. Can you imagine? I mean, like, these people are seriously out of their minds.
They're mentally ill. I am serious. They're actually sick in the head. And here's another thing that people aren't considering in this. For years, you know, when I started getting the tax resolution, I found out.
Mr. Bittner, who resided abroad and owned foreign, was not aware. Look at that. These are the facts, right? You know, these are the facts that they are presuming here. Who resided abroad? This is unbelievable.
There it is. Who resided abroad and owned foreign companies. They're not foreign when you're abroad. Stop that word. That's not the word.
In other words, Mr. Bittner, who's a Romanian citizen, is living in Romania and operating his life according to Romanian law with Romanian companies, Romanian bank accounts, Romanian investment products. And not only is he required to report this to the U.S. on an FBAR, but they're going to actually go further and impose and use him as the test case to impose the per account penalty. This is unbelievable. Stop.
Yeah, and right. And here's the thing: he's the test case, right? You're like, oh, all right, who are you? We're well, we have some press releases we want to do and rule by fear and intimidation. This is what people might not understand about how utterly destructive this is to the IRS. The IRS Office of Appeals is allegedly an independent office that's supposed to take a look at things, look at the risk of litigation, look at fairness, kind of come up with a solution. Oftentimes, that is where we come up with great solutions for our taxpayer, for our clients. IRS appeals, I would say, we do great with them. It's, you know what, generally we do good. Here and there, a few offices we're not so hot on, but generally, IRS office appeals is great. Okay, so in these cases, we get appeals of our penalties with the IRS Office of Appeals, who's supposed to be independent. And that's the furthest thing from the truth. These guys, they have their hands tied. I talk to them like, you're really going to assess millions of dollars in penalties of someone who has no money. You're really going to do that. Something they wouldn't think of doing in a million years. Now they're like, yes, we have to charge these FBAR penalties. And the reason why they become a robot is because the IRS Office of Appeals is no longer independent. There is a national FBAR penalty coordinator who tells every single IRS appeals officer what they're going to do. And that IRS appeals officer has to be the interface between the public. If you're someone who takes pride in your work, really, because I'm assuming in this case, there was probably an IRS appeals officer on this case. I assume so. And I even assume the IRS auditor or the IRS agent or examiner was probably the same way. It's like, yeah, I'm sorry, my hands are tied. I can't be reasonable in penalties. I can't be realistic because I am getting orders from above to be completely insane. So the issue here is that this is destructive. And as you say, John, this is bad for the IRS. This is bad for the IRS. You are ruining your best employees. No employee in the world can look at anyone in a straight eye and say, this is a good thing. No one can go home and say, I need to tell you what I did today, honey. What did I do? Oh, I assessed $2.72 million about a guy of his Romanian accounts. Oh, what did he evade for taxes? Oh, I don't think anything. I don't know. It doesn't matter. So that is what is utterly so poisonous. What the IRS is doing here, utterly poisonous and destructive. And it really baffles the imagination why something like this would be done. And you're left with, I think we're at war. I think the answer is we are at war. We have a occupied power that is acting so insanely. And for us not to call it, this is an act of war. What the U.S. Treasury is doing is an act of war.
How about, less emotive language, maybe put it this way, okay? Over the years, the United States has transitioned from a country based on rule of law, a sense of fairness, to rule by law, interpreting statutes literally and punitively. And this is, I think, an excellent example of this type of problem. And it's interesting that the amicus briefs are overwhelmingly in support of the per form penalty, which is good.
Are there briefs in favor of it? I didn't know.
I don't recall. I don't believe so. All right.
That'd be awful. I mean, I would hate to be that.
Yeah.
Or here's someone in support of neither party.
Well, I mean, they look at this from different perspectives, right? Everybody views these things. Actually, no, hang on a minute. There was one. Am I right that there's one from a Whistleblowers Association or something?
Hang on. Yes.
Yeah, that one I believe is, as you might expect, in support of the per account. Pull it up. Let's see what it says.
All right. Wow.
I mean, just the thought of a whistleblower association is unbelievable. Oh, look, a per account regime is not harsh and would encourage whistleblowers. Look at that. In other words, here's what they're saying in a nutshell. Okay. I mean, this is simply, it's shocking and it's depravity. Shocking and it's depravity, right?
Yeah.
What it's saying, all right, is that, by God, the court should uphold the per account penalty regime because it will increase the penalties and therefore incentivize whistleblowers to come forward. I mean, this is where the country has come to now, right? I mean,
well, look, we can see who Stephen M. Cohn represents. The answer is Washington, D.C. We can see who Rachel Tilley represents. The answer is Washington, D.C. These are all paid lobbyists. Who's paying them?
Whistleblowers.
Who's paying them to do this? My guess is the compliance industry.
Possibly.
Yeah, I mean this is utterly disgusting.
But here's the thing, right? So it is disgusting. But
it is disgusting.
If we sort of move beyond this and look at the general principle that, as you might expect, the amicus briefs are supporting the interests of the people who are submitting the briefs.
Yeah.
And I think what's significant here is the only people who have an interest in this are people like whistleblower organizations and that sort of thing. I mean, it's obscene.
Whistleblowing what though? I mean,
well, these are people who, whistleblowing is such a big industry that I think it's,
yeah, that's what it is. Right. This is an industry paper. Right?
Can you imagine an LLM and whistleblowing?
These people are, honestly, these are just, utterly amoral people who will do anything for a paycheck. That's what it looks like to me. Amoral. They will do anything. And you are a victim for them to exploit. This whistleblower. Whistleblower. Oh, well, you call yourself a whistleblower. You therefore must be ethical, right? Because you called yourself a whistleblower.
No.
Yeah.
They're amoral. They would be more evolved if they were immoral. Okay.
Right. Yes.
Step below immoral.
Right.
But right. Anthony,
wait, what's the whistleblower award? Wait, isn't there somebody who's looking for FBAR penalties? Here, whistleblowers have proven a crucial. Well, where was the whistleblower in here? Where was the whistleblower in this case? There was no whistleblower. The taxpayer was a whistleblower.
Turned himself in. Mr. Bittner turned himself in.
So how is whistleblowing relevant to this case? Whatsoever.
Because what this group can do is put together a national FBAR hunter coalition. We will hunt people with foreign accounts and turn them in. This is what this is about. So when you say
wait a second. We're getting to we're getting to what they're going for. Wouldn't you believe it? They're looking for money. Here it is. 2008, the U.S. Government Accountability Office reported that former exclusion for FBAR from whistleblower awards has a significant concern. So this is what it is. The whistleblowers want some of that money for themselves. Oh, penalize them more, then we get more whistleblower money.
I wouldn't put it that way. What they want to do is create a new industry, okay, where they can go out and hunt people down who they believe have non-U.S. bank accounts and report them, encouraging penalties in return for a percentage of the penalties. That's what they're doing, okay? And no reasonable argument can be made to the contrary.
This is disgusting. This is one of the most disgusting things. It's sort of more disgusting than the government, or it's about the same. They're the same people.
Well, it is more disgusting, okay, because let's presume that we start, with the fundamental principle that we have the governed and the government, okay, and there's this inherent conflict. These people here, these whistleblowers, they're just basically trying to find a way to profit off injustice is what they're trying to do. I mean, it really is disgusting. I mean, I question in my own mind whether whether whistleblowing should even be allowed. I mean, how is we're not far removed from the Stasi in Germany, right? In East Germany.
Well, look, if someone wants to whistleblow, they do it because they're a good citizen. To whistleblow for a crime, you end up with fraudulent things. And I just got to tell you a local story about whistleblowing and complaints, okay? Because this is sort of a little microcosm of how things actually
complain about you.
What's that?
Somebody complain about you?
What? No. This is how whistleblowers actually work. So in 1988, in my town of Wallingford, Connecticut, there was a murder. A young girl was murdered. So the family put out a $10,000 reward for witnesses that could lead to the conviction of the person who did it. Well, they found a witness who said, "Oh yeah, I heard this guy talking about it. He totally did it." Well, the witness was actually somebody I knew. I knew who the person was who was claiming this $10,000 reward. I knew that person to be a total dirtbag. No, that person's lying. That entire family is not good. They're all lying. And so they put on their testimony in court. They got their $10,000 and they convicted someone. Years later, the DNA proved he was completely innocent. And he's my age, and he did 25 years in prison for something he didn't do. Because there was a financial incentive to tell us your story. Because if someone really was in crime, I don't need money. Right? If someone's a victim of a crime, you need me to help? I'm going to help you. You don't need to pay me. I don't want, no. That's not why I'm doing it. But here we have all of these people who are just looking for any, we could steal money from it. We get our cut. Hey, the government gets their cut. Yeah, we get ours. That's what this is about. FBAR rules safeguard tax dollars. Really? What's the connection to Title 31 and Title 26, right? Right? What is this? The FBAR is independent. You don't need to have a tax liability to be assessed FBAR penalties. Slick.
Fantasy, all right, made up a bunch of people who are they're trying to create an industry of whistleblowing, and
oh my God.
Trying to do.
Oh my God. I hope they get what
people in other countries. So then they sell a franchise. They're going to get a local whistleblower association in Canada, the UK.
Right? This is who's driving it. Look at this. In tax years 2018, 2019, 2020, between 1.2 and 1.4 million FBARs were filed for each year. Kind of funny they don't know the number. Wow, we have a range. Okay, well, that sounds very scientific. And right, look, it's like, oh yeah, we're just going year by year. They don't even know. Okay, all right. However, there are approximately, here, they're giving it away, aren't they, John?
They're citing ARO, the Association of Americans Resident Abroad.
Which might be true, but there's no number, right? Obviously, however, there are approximately 8.7 million U.S. residents living abroad, and they're the same. We actually don't know if that's true. We don't know. There's no official number.
We're going to find them and turn them into the IRS. Look at this.
Right. Obviously, there is a significant delta of unreported foreign bank accounts, creating a serious area of non-compliance for the IRS. From a tax perspective, this missing piece is another scaleless slice of the overall burgeoning tax gap. Well, you're full of crap. You're full of crap because these people are paying taxes in another country. So how many times we file all the amended returns and find out, oh, you owe nothing to the IRS.
Too much language to make the point you need to make. These are bad, bad people. Okay? Isn't that it?
Yeah. I mean, this argument has they're missing, but they're bad people who are going to get it. You haven't put in any cause here, like, okay, the tax gas is estimated at some number, whatever that means. That's made up. They're pulling that out. Okay, great. Well, what is the connection between FBARs and the tax gap? There's none. The FBAR is Title 31. Okay, Bank Secrecy Act. The income tax is Title 26, the federal income tax. So what's the connection? There isn't. There's not. Yeah, not really.
Let's not.
Oh! They're getting into. FBAR. It's national security.
Anthony, regardless of the law, these are bad people. Okay, that's the point that needs to be made here. And this whole thing that they're submitting, should be completely discredited.
Oh my goodness. Oh yeah, they're going for. They're citing the Patriot Act. Well, they must be patriots, right? The whistleblowers citing they can't have their own selfish interest here of trying to glom onto this entire theft. Whistleblower incentives work. Really. Mm-hmm. Oh, see, they're talking about Birkenfeld because this is what it was about. He wanted he was involved in it. Oh, but I'm going to rat these people out. Give me money. Birkenfeld is the reason why you shouldn't have any whistleblower. There's no reason. He's the reason why you shouldn't. He was one of the most dishonest people in the world who's getting rewarded for his $100 million. He encouraged people to intentionally break the law. Hey, yeah, we'll meet in New York and we'll discuss this over here. Yeah, if you move it over to Switzerland, you won't get taxed. Here, shh. He was the one leading the charge. And now look at this. These guys are arguing. Oh, he needs to get his $100 million reward because it's so helpful.
Anthony, let's not lose sight of what they're saying. What they're saying here is there's approximately 6 or 7 million Americans abroad who may not be filing FBARs, and it should be a per account penalty base to benefit whistleblowers who can go out and find them and turn them in. That's all this is saying, right? Okay. Now, the Treasury does have the statutory authority. This comes right from the statute itself to exempt Americans abroad from the FBAR thing, right? Anyway, this is, oh my God, look at this, Gabriel Zucman. Now they're citing Gabriel Zucman. This is the guy, the wealth tax apologist. It's all over the place.
Oh.
I mean, anything they can find that legitimizes the confiscation of the assets of hardworking, honest people, this Whistleblowers Association is going to find and use. It's amazing stuff.
They are disgusting. Utterly. This is just the most naked, terrible thing.
Oh my God, now look at this.
I wonder why lawyers get a bad rap. Here it is. Here's why. I mean, these people are, I wouldn't call them lawyers. You got to be a person first.
Listen to this. Holding for the petitioner's per form approach would take the teeth out of the concept of the FBAR and run counter to the statute's original intent. What a bunch of morons. Okay, Anthony. Enough. I don't want to get as excited as you are, okay?
Oh, God, it's crazy. Yeah, all right, we got to dial. So here we go. So let's go back. So we got...
Look, here's their reason. Their argument is it's going to deter whistleblowers. It will deter... Well, look at this. The Ninth Circuit decision in Boyd is not, and if accepted, will deter... The whole thing is we want to enable whistleblowers. What better way to do it than give them a better take on the whole thing? What better way to give them a better, bigger take than a per account penalty base? This is unbelievable. And people wonder why in Shakespeare's whatever it was, they said, let's kill all the lawyers.
I know, right? This is, look, then it is the truth. A lot of people go to law school because they don't have a lot of other options.
Well, it's because they can't do math, Anthony. That's the
right. They can't do right. So they go to law school. And hey, look, it's good. Hey, look, it's better than other things you have to do. It's better than working for a living, right?
Anyway.
This is where, these people ruin the attorney name. These people are responsible for the public with good reason for hating attorneys. These people should be sanctioned and should be disbarred. That's my opinion. This is completely disgusting. They want the law to be turned just to be their personal cash cow. That's what it all is. Here it is. If you want to know why, if you want to know who it is, here it is. They're on they're right in Washington, D.C. Believe it or not, there's their emails. If you want to reach out with them with questions, I'm not going to bother them. I mean, there's no point. They're completely for sale.
What they're doing is they're lobbying the Supreme Court to create a special industry that will legitimize and make it profitable to go out and find people who may have non-US accounts and turn them over to FinCEN to be fined. Okay, that's really what they're doing. Okay, no need to get excited and emotive about it. Okay, the facts speak.
What do you mean? I can't get excited and emotive about that.
Facts speak for themselves.
I was very calm before this, by the way.
I know.
I know.
Well, this is what happens. You know, we get started, you get more and more excited. Okay, I worry that you're going to have a stroke one day. We certainly don't want that. Okay.
Well, I guess the thing that would relieve a lot of my anxiety is if we actually had a nation of laws, as we talked about.
You mean
we actually had a system where our representatives voted on laws, and then the laws are what the laws were. That would really relieve my anxiety, because in that situation, what we would have is a representative democracy or a republic, right? So if we actually had laws that people voted for and were accountable for, then I'm like, oh, it'd be a lot easier. But here, we don't have an FBAR law. There is no FBAR law. There's an FBAR regulation. How legal that is, we'll find out. Hopefully someday we do.
Wouldn't you like to be in a position to be able to just sanction people for no reason? I mean, this is perfect.
Well, as long as I get a cut, I guess. If I can sanction them, I don't get the money. Well, then that's a problem. But right, I guess as long as these folk are cut in, as long as they're cut in on it, they're like, oh yeah, we'll help you out here, government. But imagine their public service evaporates, though. Man, that's funny. So it's like, the argument would be, no, I think we should get rid of the whistleblower complaint, because whistleblowers who are not reliable witnesses are more harmful than good. And by throwing this money around, you are only going to ensure you get the worst whistleblowers.
Well, you're gonna get stuff manufactured. Okay, there's a lot of, I think this person might have a foreign account or something.
Yeah, a lot of manufactured seizures, and this is what they're going off of. Hey, we have this thing.
I got a question for you.
Yeah.
Do you have a second citizenship?
No.
You need to get one.
I could have years ago. I missed my opportunity.
Maybe you can reactivate it, but you need a second citizenship.
Really? You think so?
Well, it's going to take a long time to get this stuff reversed, okay?
Well, I guess it's like, okay, fine, but then what's the country I go to?
I don't know.
That's the problem.
We'll have to check around.
That, every country is sort of, as we've talked about before, every country's rolling over for the IRS. We talked about that in the last one, at Canada and New Zealand. We talked about that, or that's coming up. I'm going to be uploading that.
Separation. I mean, here's the point. If you have another citizenship, at least they can't keep you in the, you've got another passport. You can go somewhere. That's good. You've got a place to go. But we'll make that for another podcast. Anyway, here's the deal. Okay, for if everybody's listening to this. This is very interesting. It's a very important case, I think, for Americans abroad. I think it is worth paying attention to this, and you can even listen in on the oral arguments this Wednesday, November the 2nd. I think it starts at 10 a.m. Just go to supremecourt.gov, and we'll discuss this again after. But this is important stuff. And I want to give a shout out to Nina Olson, the Center for Taxpayer Rights, and their lawyers who've done a fantastic brief on that.
We'll get back to the good brief here. Yeah. Here's these are good people here. Yeah, they're doing good arguments here.
That's right, because in our simple world here, we have good people, and the whistleblowers are bad people. Good, bad. Okay, so I mean, we have all the right kinds of players going on here. There's no gray. There's no ambiguity. We have the white knights here, and the black knights, the dark knights. Okay, in the form of the Whistleblowers Association. So there you go. So what do you think, Anthony?
Well, our quick video on this turned into an hour.
Give me a prediction. I woke up to people predicting, would the Patriots beat the Jets or vice versa? Now let's move on to something even more important. Will the White Knights beat the Bad Knights or vice versa?
I'm going to find out here. I mean, you know what? Here's the thing. I have hope. I do have hope. And if it wasn't for EPA versus West Virginia, I'd be like, yeah, I'm not even going to look at this because I know which way it's going to go. right? I wouldn't even look at it. I wouldn't even bother my energy.
I'm not so sure about that. Here's the thing. I mean, I know people don't like this, consider this to be a highly politicized Supreme Court, and a lot of people don't like it. But my reading of this court is they might read the statute. Okay, they might actually read the statute. And that would be.
I'm secretly hoping they watch this podcast and then they're like, oh, wait a second. The statute doesn't say that.
Right. They all seem to assume it does when it doesn't.
Please read the law. I hope one of their clerks, I hope their clerks like, wait a second.
Alito was very, very clear that there's nothing in the Constitution that provides a right of privacy, right? I mean, he reads that, the terms of laws and statutes. And, I think that certainly that whole group of people in the court are likely to actually read the law. And, Anthony, that's, it's such a remarkable thing in the 21st century to approach a legal issue by beginning with a reading of the law, don't you think?
Well, that's kind of where, that's where I've noticed about the government's brief. They don't really they say what the law is, but they don't quote it. Like, oh, okay. But we're talking about a statutory interpretation, right?
Star chamber.
We won't have that statute.
Star chamber. The government will determine who's deserving of punishment, and we need the flexibility with FBAR penalties to punish them appropriately. That's what they're really saying.
All right. So, but this decision we're not going to get until probably May, June.
Don't worry, we're both going to be alive to discuss it.
All right. Well, it's too late to call our predictions, or do you think it is? Got any prediction?
Yeah. I'm going to predict that it comes down to penalty per form, and not per account.
All right. I'm gonna go out of the park. And I think your prediction is the reasonable one, and I think that is what normally would happen. But I'm praying. I am praying they look at the whole statutory scheme. And I'm praying that they apply their brain power to the entire statutory scheme, and they'll end up with the same conclusion that we've left.
Anthony, I'm just praying they read the statute. I don't think they need to apply their brain power at all. I think they just need to read the statute. I mean, really, one thing about having a bunch of lawyers on the side of any issue is after a while you can't even remember what the issue was. And, you get this impression when you read some of these briefs, particularly this nonsense. Apparently the issue in FBAR is that there ought to be an industry where one group of people can turn another group in for penalty relief. That's apparently the issue in the case, right? I mean, that's
right. The Title 31 wasn't passed because, there's unrepresentative whistleblowers. That's not the reason it was passed.
No, Anthony. It was obviously passed to benefit whistleblowers. It's just taken a lot of years to recognize.
It took a lot of years for the industry to get off to get going.
Get with the program here, okay? I mean, these laws have shifting, and these people just woke up and said, "Oh my God, look, this economic opportunity. The purpose of FBAR must provide remuneration for whistleblowers, right?" It really is disgusting.
Yeah. So wow. Okay. So we'll end it here at an hour, John. This is you got me all fired up.
I can see that. Sorry about that, Anthony.
It was a Monday, and I'm all like, okay.
For the rest of the week now, do you?
What's that? Oh, I got a bunch of stuff to do.
Well, Anthony, I expect you to be there.
I'm fired up, though. I'm motivated, I guess. I am motivated.
I expect you to be there at 10 o'clock and Wednesday.
10 o'clock, we can listen live. 10 o'clock on Wednesday.
Earl and Anthony will be listening.
All right. Well, thanks again, John. Hey, and we're really looking for some commentary on this, and spread this around. And really, we're seeing I think we've actually distilled it down to the nonsense. Really, who's driving it, right? We're seeing the parties who really are, the conspiracy of the people driving this illegal interpretation of a statute that clearly says foreign financial agency. And clearly defined a foreign financial agency as another person, clearly defining a foreign financial agency as not a foreign bank.
Anthony, you're getting too intellectual on me again. How about just this?
I was just reading the statute.
How about it's just not fair, okay?
It's not fair. It's nuts.
All
It's
right.
time. All right, we're not going to take it anymore. There you go. All right.
Talk later and go, go ride your bicycle for a
Oh, I
while.
got to do that. Yeah, you're right. All right,
All
good
right.
call. All right. Well, thanks, John. Have a great day.